Director of Training at the National Fair Housing Alliance in Washington, D.C. If you can hear me, then you're logged on properly, and we will begin the broadcast at 2 o'clock. Thank you. You can, however, begin sending us questions, but please don't raise your hand. Just use the questions toolbar on the right-hand side of your screen. Thank you. Hello, this is Diane Cipollone. Thank you for joining our webinar. If you can see the screen that has training, condominium, cooperatives, and homeowner associations with the NAFA, National Fair Housing Alliance logo, then you have logged on properly. And if you can hear me, your audio is working properly. We will start the webinar in about 2 minutes. Thank you very much. If you have any questions, please use the questions toolbar on the right-hand side of your screen, and you can start sending your questions now. Do this instead of raising your hand. Thank you. And yes, we will provide a copy of the presentation. You will get an email probably sometime tomorrow with a link to download the presentation, and we will ask you to complete a very brief survey. Thank you. Hello, this is Diane Cipollone. I'm the Director of Training at the National Fair Housing Alliance, headquartered in Washington, D.C. Thank you very much for joining us today. We are ready to begin the webinar. I'd like to introduce our presenter, Kevin Cremin. Kevin is an attorney and Director of Litigation for Disability and Aging Rights at MFY Legal Services in New York. And before I hand it over to Kevin, just to mention again that everybody who attends today will receive an email probably tomorrow with a link to download the presentation, and we'll ask you to complete a very brief survey because we want your feedback on all of our trainings. Thank you very much, and I'm ready to have Kevin begin.
Well, I appreciate the opportunity to speak to you today. I'll give you a quick roadmap of the training. First, I'll give an overview of the Fair Housing Act, similar to one that I might give when I provide training to real estate agents, landlords, homeowners associations, or a co-op board. Then we'll discuss some particular problems that come up in the context of condominiums, co-ops, and homeowners associations, and go into those in a little more depth. For the Fair Housing Act, we'll look at who's protected, what types of housing are covered, what the Fair Housing Act prohibits, who's liable for violations of the Fair Housing Act, how the Fair Housing Act is enforced, and what are the punishments for violations of the Fair Housing Act. With regard to condos, co-ops, and homeowner associations, we'll look at the wide range of issues listed on the slide with a particular focus on questions that come up in these contexts. Now, normally when I give a training, and I often train real estate agents or associations, etc., and they're almost always in person. And before even really introducing myself or having the trainees introduce themselves, I jump right into the training. And I do this for at least 3 reasons. One, to show that I appreciate that the audience very well might already have significant knowledge about the Fair Housing Act. 2 is to try to get a sense of what areas the audience already knows and what areas I might need to focus on during the training. And 3, to try to engage the audience from the very start and make it clear that I want the training to be interactive. Because even truthfully, when I train in person a group of 200 plus real estate agents, I still try to make it as interactive as possible because I think that that's a more effective type training. And so there are many ways to do this, but I almost always start by asking the question, who is protected by the Fair Housing Act? And in that spirit, let's begin with a few polls. So I'm going to start the first poll, which is which of the following protected characteristics are protected under the Fair Housing Act? And so you select all that might apply. Which of the following characteristics are protected under the Fair Housing Act? All right, I'll just give you maybe another 10 seconds or so to finish up with the first. And then we'll move right on to the second, which is the same question with some additional options. All right, well, let's actually first share the poll results there. Okay, so as you can see, approximately 43% of the people selected age, and 27% citizenship status, 97% color, 97% familial status, and 88% gender. And so age is the one I find trickiest. I often forget that age is actually not protected under the Federal Fair Housing Act. And I forget that in part because, at least in New York, it is covered by the New York State Human Rights Law and the New York City Human Rights Law. And so depending on where you are, age might be protected under state and local law, but it is not covered under the Federal Fair Housing Act. And the same can be said of citizenship status. Citizenship status alone is not covered by the Federal Fair Housing Act, but is in New York, for example, covered by the New York City Human Rights Law. Now, 97% of you chose correctly that color and familial status are covered by the Federal Fair Housing Act. And now, gender. Gender is another one that I guess it depends potentially how you look at it. Sex is covered by the Federal Fair Housing Act, and that'll come up later. Gender as distinct, gender expression which might be distinct from sex, is covered by the New York City Human Rights Law. It might be covered by state and city law where you are as well, but that is the start. So let's move on right on to the second poll, which is the same question: which are protected characteristics from the Fair Housing Act? Select all that apply. And so some of these might be covered by the Federal Fair Housing Act, some might not. All right, now we'll then spend maybe about 30 more seconds or so on that before I share the results. Okay. So I'll wait a few more seconds, and then I'll close that poll and share the results. Okay, so this one, in this, 2 of these categories are protected by the Federal Fair Housing Act. 96% of you were correct in choosing handicap, or more commonly, I tend to say disability, and national origin, 95%. And those are correct. Those are both covered by the Federal Fair Housing Act. Marital status is not covered by the federal law, but it is covered in New York, for example, by the New York State Human Rights Law and New York City Human Rights Law. So depending on where you are, marital status might be protected, but is not actually covered by the Federal Fair Housing Act. Military status, also not covered. It is covered in New York State by the New York State Human Rights Law, and there's been some talk of potentially amending the federal law. At least there's a proposal to amend the federal law to cover military status, but that has not gone into effect or been passed as of yet. So military status is not covered by the federal law, and neither is occupation, though in New York City, at least, lawful occupation is covered by the New York City Human Rights Law, and so that would prohibit, for example, which is an example often used in trainings, discrimination against lawyers, for example, even though there might be reasons why a landlord or co-op associations might not want to rent to or sell to an attorney. That would be prohibited by the New York City Human Rights Law in New York, for example. And so I'm going to move on to the third poll, which is the same question: which of the following characteristics are covered by the Federal Fair Housing Act? And there's 5 choices, and some of these might be covered by the Federal Fair Housing Act. All right, we'll just spend a few more seconds on that and then move on. Okay. I'm going to close the poll now and share the results. So now most of you are exactly on target on this one. The 3 remaining protected characteristics under the Fair Housing Act are race, religion, and sex. Sexual orientation in New York, for example, is covered under New York State Human Rights Law and New York City Human Rights Law, and that might be the same in other parts of the country or some other parts of the country, but sexual orientation is not covered by the Federal Fair Housing Act, and neither is lawful source of income. Lawful source of income is a provision that was added to the New York City Human Rights Law recently, and that I'll just let you know, though of course it's not covered by the federal law, you might just be interested in knowing that lawful source of income protects people from being discriminated against based on, for example, them paying their rent with a Section 8 voucher or with Social Security benefits or with other lawful sources of income. Okay, so I'm going to hide those results now and we'll move on. So as I said, when we're focusing on the Fair Housing Act, we'll look at those topics, and then moving on towards the, I'm sorry, forgive me for a second. So as I said before, when I start a training, I ask who's protected under the Fair Housing Act, and sometimes I get a range of answers, including Black people, Latinos, people with disabilities, and those are all partial correct answers, I guess I'd say. But normally I get at least one person in the room that says what I consider to be the correct answer, which is everyone. Everyone is protected under the Fair Housing Act. And as kind of demonstrated by the polls we just went through, there are 7 protected characteristics under the Fair Housing Act: race, color, national origin, religion, sex, family status, and handicap. But it is worth noting, again, as pointed out by the polls, that some state and local laws can provide additional coverage. For example, the New York State Human Rights Law covers age, marital status, military status, and sexual orientation. And the New York City Human Rights Law is even more expansive. It covers age, citizenship status, domestic partnership status, gender, marital status, lawful occupation, sexual orientation, and lawful source of income. And so since there are people from across the country in this training, we'll focus on the federal law, but it's worth noting, and I will note at various points where state and local laws might provide more expansive coverage. Normally then, again, as a training, I'll just note that I often give a Fair Housing Act quiz. Again, kind of, acknowledging that people in the audience often have a baseline of knowledge about the fair housing laws, and I'll just encourage the audience to shout out the answers. So I'll ask a group of agents I'm training, for example, true or false, applicants with children can be rejected due to concerns about lead poisoning. And so people in the audience will shout out their answers, and the answer to that is false, as we'll talk about later. And actually, why I like this example about lead poisoning is that it points out that even if an action that someone takes is motivated by good intentions, like protecting children from lead poisoning, you still might be discriminating. Because, for example, rejecting applicants with children for whatever reason that is based on the fact that they have children would be discrimination under the familial status provisions of the Fair Housing Act. And I also might ask, and normally I'll go through like 15 or so of these, I'll just give another example. I might also ask the following. A cooperative may not obtain a pet deposit from residents who will have a service animal living with them. True or false? And the answer to that is true. Because the service animal is not a pet, a cooperative or a apartment building or management company cannot obtain a pet deposit from a resident who will have a service animal living with them. And I note those 2 examples. I won't go through any others, just because I generally find that audience that I train, whether they're real estate agents, co-op boards, cooperatives, Homeowners Association often struggle most with the topics of familial status discrimination and disability discrimination. And there could be some theories as to why that is. They are two of the newest provisions of the Fair Housing Act, and so that might be, even though they've been around for a while, that might be part of the issue. So let's talk a bit about familial status discrimination. So who is protected by the familial status provisions? As set forth on the slide, the Fair Housing Act prohibits discrimination against families with one or more children living with a parent or a person with legal custody of the child or children, or the designee of the parent or the legal custodian. And it's also worth noting that the family status provision also protects people who are pregnant or in the process of securing legal custody of a child. Later in the training, we'll example a number of examples of familial status discrimination in the context of condos and co-ops. So who is protected by the Fair Housing Act's handicap provision? The Fair Housing Act covers people who have a disability, and for the purpose of the Fair Housing Act, a person has a disability if they have a physical or mental impairment that substantially limits one or more major life activities. And major life activities might include seeing, hearing, working, etc. Things that for many people are things that they do on a daily basis. And it's worth noting that some state and local fair housing laws have a more expansive definition of disability. They might not require a person to satisfy all the elements of this definition. And so that depends, of course, on your state and local law. But that's one way in which some state and local laws differ from the federal law. It's also worth noting that the Fair Housing Act provides protection for people who have a history of an impairment or who are regarded as having an impairment. And as we'll talk about later, reasonable accommodations and reasonable modifications are questions that often might come up in the context of co-ops or condos, and we'll spend more time on those later on in the training. So next, we will look at what types of housing are covered by the Fair Housing Act. And so as leading up to that, we'll do another poll, which is which types of housing are covered by the Fair Housing Act. So which of the following types of housing are covered by the Fair Housing Act? And we'll spend a few more seconds, maybe 15 more seconds, to let you all answer, and then I'll share the results. Okay, I'm going to close the poll and share the results. So as you can see, the majority of you thought that each of these types of housing are covered by the Fair Housing Act, and that's exactly correct. Definitely condominiums, cooperatives, public housing units, which the vast majority of you thought are covered by the Fair Housing Act, are covered by the Fair Housing Law, and less well known but still true, assisted living facilities and nursing homes are also covered by the Fair Housing Act. A nursing home cannot, for example, refuse to take residents based on their race, and neither could an assisted living facility. And so that's less well known, but definitely true in terms of what types of housing are covered. And we'll, and the main thing to remember is that all of these types of housing are covered by the Fair Housing Act and obviously a wide range of others, and that the Fair Housing Act broadly defines the term dwelling, and the exceptions to coverage are quite limited, as we'll see. So I will now move on to what types of housing are covered by the Fair Housing Act. So as I said, most types of housing are covered by the federal law. Though it is worth noting, in some circumstances, the Fair Housing Act exempts owner-occupied buildings with no more than 4 units, single-family housing sold or rented without the use of a broker, and housing operated by organizations and private clubs that limit occupancy to members. Again, it is worth noting that some state and local laws have even more limited exceptions. Those are pretty narrow exceptions to the federal law, and some state and local laws have even more limited exceptions. And so that is the types of housing covered. If you're training cooperatives, condos, or homeowners associations, I mean, it's worth obviously emphasizing to the co-ops and the condominiums that they are covered by the Federal Fair Housing Act. And they might have questions about that. Definitely the question that comes up from agents quite often is whether cooperatives are covered by the Fair Housing Act, and they certainly are. Okay. So what does the Fair Housing Act prohibit? As we can see here, the Fair Housing Act prohibits discrimination in the context of sales and rentals, prohibits discrimination in the context of mortgage lending. It also prohibits interfering with people exercising their fair housing rights. It prohibits discriminatory advertisements and statements, and it also prohibits disability discrimination. So we'll go through each of these categories of prohibitions under the Fair Housing Act. In the sale and rental of housing, the Fair Housing Act prohibits a wide range of acts if the acts are taken on the basis of protected characteristics. And that's important to note because one can refuse to rent or sell housing if someone can't afford the housing. One cannot refuse to rent or sell housing based on race or any of the other protected characteristics. And so that is an example, and the other examples are listed on this slide of what's prohibited in the context of rental and sales. One example that I sometimes like to highlight when I'm speaking to an audience, a co-op board or condos, is the falsely denying that housing is available for inspection, sale, or rental. And so that is G on this slide. And it's worth noting because there is, based on my experience training, there is a lot of, I guess the word I would say would be resentment or unhappiness by agents or co-ops or condos about testing. And so because people are often interested about the topic of testing, I point out this example. I think this is a useful example of pointing out why testing is useful or necessary to uncover discrimination, because, of course, if someone's told that there are no units available, they have really no way necessarily of knowing whether or not that statement is true or not true, and so they might just move on. But testing, obviously, when people are sent, so for example, 2 adults go to ask whether a unit's available, and they're told that one is, and then 1 adult and a child goes and told, and they're told that no units are available. It certainly raises the question as to whether or not they are, being discriminated against based on family status, and whether there's a false denial that housing is available that's going on in this context. Now, mortgage lending, discrimination mortgage lending is also prohibited by the Fair Housing Act. And so obviously if a bank or other entity refuses to make a mortgage loan based, for example, on race or based on disability, that would be a violation of the Fair Housing Act. So it would be imposing different terms or conditions on a loan based on race or disability, for example. And there are, as you might know, examples of redlining or reverse redlining, which are pursued as discrimination under the Fair Housing Act. A little bit outside of the scope of what we're talking about today, so I won't spend too much time on that. Now, the Fair Housing Act, as I also noted, prohibits interfering with anyone asserting their fair housing rights or helping others assert those rights. And so, when training real estate professionals, co-op boards, condos, et cetera, it is worth noting to them that they, whether in their individual capacity or in their work capacity, cannot be retaliated against for helping people exercise their fair housing rights. And of course, in advertising, the Fair Housing Act also prohibits statements that indicate a limitation or preference based on a protected characteristic. And advertising is a topic that often I find people I'm training are quite interested in, and we'll talk much more extensively about advertising later in the training. So and it's worth noting, I'm sorry, that this prohibition against discriminatory advertising, which is found in Section 3604C of the Fair Housing Act, it applies to properties such as single-family houses that might otherwise be exempt from the Fair Housing Act. All right, so we've talked about the different protected characteristics and the prohibitions of discrimination, and so I wanted to ask next what in 2002 was the most common basis for a housing discrimination complaint. So was it familial status, handicap, national origin, race, or sex? 2002. I'm sorry, 2012, excuse me. Okay, so I'm going to now close the poll and share the results. So the majority of you are absolutely right. 69% of the handicap was the most common basis for a complaint in 2012, and that is exactly right. In fact, approximately 50%, or almost half, of the 20,000 discrimination complaints that National Fair Housing Alliance members received during 2012 were based on disability. And you could find this and other useful information in the NFHA's publication, Modernizing the Fair Housing Act for the 21st Century, which can be found for free on NFHA's website. And that's cited at the bottom of the current slide. And this is a pie chart just showing the breakdown of the complaints. So the second most common basis was race. Because it is somewhat different than some of the other protected characteristics, let's spend a few minutes on disability discrimination as a basis, as a prohibition under the Fair Housing Act. Discrimination includes refusing to make reasonable accommodations, which are changes to policies, practices, or procedures under the Fair Housing Act, and requests for reasonable accommodations, which are requests to make physical modifications to a unit or a common area. And then we'll talk about these more later. But it's also just worth noting that beginning in 1991, discrimination has also included the failure to design and construct buildings that have 4 or more units in an accessible manner. So who's liable for discrimination under the Fair Housing Act? Any person or entity who engages in conduct that's prohibited. And that includes individuals, corporations, condominium associations, et cetera, lenders, real estate agents, and state and local governments, of course, if they engage in prohibited conduct. So how is the Fair Housing Act enforced? How do people be found liable for discrimination? So we'll talk about who can file a complaint, where a complaint can be filed, and when a complaint can be filed. So an aggrieved person can file a Fair Housing Act complaint. An aggrieved person is someone who claims to have been injured by discrimination or believes that such an injury is about to occur. The Attorney General of the United States can also file a complaint. And that's in particular if there is an alleged pattern or practice of discrimination or when the denial of rights raised to an issue of general public importance. Now, where can a complaint be filed? An aggrieved person is presented with a choice. They can file an administrative complaint or a civil action. Unlike in some other settings, for example, in employment discrimination, there's no requirement that a person first file an administrative complaint. So some of you might be familiar with the term exhaustion. There's no requirement that one exhaust their administrative remedies under the Fair Housing Act. And so when should a complaint be filed? Administrative complaints have to be filed within 1 year of the alleged discrimination. If an aggrieved person wants to file a civil action, they should do so within 2 years of the discriminatory practice. It's worth noting here, as I've mentioned at a couple other points, that some state and local fair housing laws have longer statutes of limitations. What are the potential punishments for violations of the Fair Housing Act? Injunctive relief, compensatory damages, punitive damages, civil penalties, reasonable attorney fees, and costs. I find when I'm giving a training, it's often helpful to give a concrete example of the punishment. So in New York, I often note the punishment issued in Broome versus Biondi, which is the case that involved the Beekman Hill House, which is a cooperative apartment building in New York City. In that case, the people who were discriminated against received $230,000 in compensatory damages, $410,000 in punitive damages, and that is just an example of sort of the magnitude of the punishment that can occur if there is discrimination. Now, of course, even severe punishments might not fully compensate the victims of housing discrimination who may have lost access to housing, access to family and friends, access to employment, access to education, access to equity, access to amenities like public transportation or parks, et cetera. All those reasons why people choose to live where they live. So during the remaining time, we'll focus on the 11 topics on this slide, which are topics that tend to come up in the context of condos, co-ops, and homeowner associations. But first, I just want to take a step back and examine the prevalence of condos and co-ops throughout the country. When I was asked to do this training, I knew that co-ops and condos were common in New York, but I wasn't sure how prevalent they were in other places. According to the 2011 American Housing Survey, there are approximately 10 million co-op and condos co-ops and condos in the United States. And as you can see on this chart, the vast majority of those are condos. I was also curious about where co-ops and condos are located. And unsurprisingly, the majority of co-ops, or at least unsurprising to me, the majority of co-ops are located in the Northeast because they're relatively common still in New York. And but that being said, as you can see in this chart, the distribution of condos essentially mirrors the distribution of all housing unit types in the United States. There are about 20% in the Northeast, 19% in the Midwest, 33% in the South, and 27% in the West. That's the percentage of all condos in the United States. And here's a chart which just depicts that regional distribution. You can see the only real outlier is the percentage of co-ops. And as I said, it's probably not too surprising for most of you that the majority of co-ops are actually located in the Northeast. Now, who lives in co-ops, condos? There might be other data sources. I was curious if there are any demographic trends apparent from the American Housing Survey data. But as you can see in this chart, the data doesn't necessarily really show any obvious trends in terms of the occupants of co-ops and condos, because they basically mirror the occupants of all housing unit types. The only notable difference is that a substantially higher percentage of co-op units are occupied by people who are 65 plus. This might be relevant in terms of thinking about familial status discrimination in the context of co-ops, or in states or cities where age discrimination is covered. That might also be relevant. So we'll talk now about restrictive covenants, which are something that come up in the context of co-ops, condominiums, and homeowners associations. Now, race restrictions or racially restrictive covenants prohibit the purchase, lease, or occupancy of property by a particular group of people based on race. And this is an issue that was litigated even before the Fair Housing Act came into effect. And as you can see, in 1948, the Supreme Court held that racially restrictive covenants themselves were not unconstitutional, but the enforcement of the covenants is. But it's worth noting that even unenforceable covenants excluded people through steering, because they obviously send a pretty strong signal that people are not welcome based on their race. Now, of course, the Fair Housing Act banned racially restrictive covenants, but there are some that are still on the books of co-ops, cooperatives, co-ops, condominiums, or homeowners associations. And those are obviously violations of the Fair Housing Act. Occupancy restrictions sometimes come up. Now, when I discuss familial status discrimination, co-op boards, condos, real estate agents often ask whether this means that they have to allow huge groups of people to live in, for example, a one-bedroom unit. And the answer is a qualified no. While occupancy restrictions can violate the Fair Housing Act's prohibition against familial status discrimination, under what's known as the Keating Memo, which is a HUD memo, an occupancy policy of 2 people per bedroom is reasonable. However, of course, the reasonableness of that policy is rebuttable, and HUD will look at factors such as the number of sleeping areas or bedrooms, the size of the sleeping areas or bedrooms, and the overall size of the dwelling unit. Now, of course, I would think also that local market conditions would be relevant. Probably more people, larger groups live in a one-bedroom unit in New York City than in a rural setting. So that might be something to look at as well. Age restrictions are another, and I'm sorry, going back to occupancy restrictions, I just want you to note that the key to this is if there is an occupancy restriction by a condominium or a co-op, it has to be applied consistently. So for example, if the co-op or condominium is allowing 2 people per bedroom, it shouldn't matter whether those 2 people are 2 adults or 1 adult and 1 child, for example, right? Because if it were to matter, then that would essentially be familial status discrimination. With regard to age restrictions, although, as I said before, age discrimination is not a protected characteristic under the Fair Housing Act, occupancy, like occupancy restrictions, age restrictions can constitute familial status discrimination. Because, for example, if a co-op had a rule that no one under the age of 21 or 25 or 35 or 55 could live in the co-op or condominium, then that would obviously prevent families with children from living there, and that would be familial status discrimination. That being said, there is an exemption, which is worth noting, which is housing for older persons. And as it states on this slide, housing for older persons is exempt from the prohibition against familial status if any of these 3 conditions that are set forth in the slide exist. For example, if the complex is intended for and occupied solely by persons who are 62 or older, to give one of the 3 examples. It's worth noting that the housing for older persons exemption applies only to familial status discrimination. Housing for older persons cannot discriminate based on race, religion, or any of the other protected characteristics. It is only an exemption to the familial status provisions of the Fair Housing Act. Advertising. As I noted before, when I do a training, people are often interested in advertising. And as you might know, there are lists that you could find on the internet of words to avoid or terms to avoid. And I think some of those lists might be over-inclusive, some might be under-inclusive, and it's really probably impossible to build an entire list of terms that one would want to avoid in order to not state a preference or a limitation based on a characteristic that's protected by the Fair Housing Act. So one of the things that I often do is I go through when I conduct training is I go through approximately 25 examples with people shouting out their answers as a way of not necessarily answering every question that people might have, because as I said, that would be impossible about advertising, but as a way of reinforcing the protected characteristics and helping people develop a way to approach Fair Housing Act questions. So if I give an example, for example, that would say no children, is that okay, or is that something that you'd want to avoid? People would presumably shout out that's something that they'd want to avoid, and then I'd ask them why, and then hopefully they'd say because that would be familial status discrimination. And so it's a way of helping people develop sort of a method to handle Fair Housing Act questions, because it is impossible to give people, the answers to each and every question that might come up. So we'll just do 30 seconds on a couple of polls, which are, the first one's which phrases would you avoid including in a housing advertisement? And I'll launch that poll now, and we'll give about, actually let's just give like 15 seconds so you can kind of just go on your gut as to whether this is something you'd avoid under the Fair Housing Act or not. So you select any that you'd avoid under the Fair Housing Act. Okay, I'm going to close that poll now, and I'll share the results. So in this one, 100% of you were absolutely right. Christian summer preferred would be something you'd want to avoid because that would state a preference or limitation based on religion. Empty nesters only is something you'd also want to avoid because that would, again, state a preference limitation based on family status. No pets is something that would not be something I would avoid under the Fair Housing Act. It is true that the condo or the co-op would have to, as we'll talk about later when we talk about reasonable accommodations, have to make reasonable accommodations if a person wants to or needs to use a service animal, but no pets in and of itself I would say would be okay under the Fair Housing Act, and would be not something I would want to avoid as long as they're clear, if asked, that they will grant reasonable accommodations for service animals. And master bedroom and your public transportation, I would say would be okay. And so let's quickly go to a similar poll, which is again just a few more examples, so you can kind of just go quickly through and pick which are the ones you'd avoid in a housing advertisement under the federal law. We'll spend a few more seconds on that. Okay, I'm going to close out the poll and share the results. So now this one is something that I think can be a little bit controversial, but in terms of near a synagogue, I would avoid it based on the fact that it might be interpreted as expressing a preference or limitation based on religion. I think that there could be arguments made to the contrary, but I think most people would want to avoid that, and that was certainly the case with you all. Chinese preferred, pretty obviously, national origin discrimination, must be able to live independently, would be disability discrimination. No lawyers, it's actually okay under the federal law, but as I noted before, under some state and local laws, lawful occupations are protected. But under federal law, it would actually be okay to say no lawyers. And you might want to avoid it for other reasons, but under the federal law, it would be okay. And credit check required would not be problematic under the federal Fair Housing Act. All right. So as we could tell from these examples, words do matter. And the Fair Housing Act, as I said, prohibits any statement that indicates a limitation or preference based on a protected characteristic. And it's worth noting that this would also include, if they're made public, especially newsletters or other publications that sometimes larger condos or co-ops or homeowners association make available to the public. And just note a best practice in this slide that often co-ops, condominiums, and other entities are encouraged to use the term or the words equal housing opportunity in all their advertising and promotional materials. So on this slide are just some examples of discriminatory advertising, and the examples I think are pretty self-explanatory, especially regarding the no children example, which I noted before. But it's not just words that matter, also the images used in advertising are relevant. If a co-op or a condominium or a homeowner association only uses people of one race in their advertisements, then that can raise the issue of whether they're stating, at least implicitly, a preference for people of that race. And the same would go if there are only people of one sex or no children, et cetera, depending, perhaps on the scope of the advertising campaign. But it's not just the words, but also the images. And also the placement of the advertisement. So we run into this sometimes as an issue in New York where a large-scale complex will only place advertisements in, for example, a newspaper that is geared only, that's in Russian, for example. And so if it's a large complex, it certainly raises the question as to whether or not they're expressing a preference for people from Russia, if they were to do so. So applications. So I think the big question that comes up with applications for condominiums or co-ops is, why are they sometimes collecting information on which a decision cannot lawfully be made? And so potentially problematic questions include those that inquire about applicants' race, religion, sex, or the ages of the occupants. And now I see these on applications pretty consistently, and I think that's in part because they're models that are replicated from before the Fair Housing Act or without thinking about the Fair Housing Act, but it is worth raising the question as to why they'd want to collect information about which a decision can, on which a decision cannot be made. And often what is encouraged in lawsuit settlements, et cetera, that I've seen is that applications should have an equal housing opportunity statement on them, noting that the co-op or the condominium homeowners association does not discriminate on the basis of any protected characteristic. Of course, you'd want to include those protected under the state and federal law as well, if there are any applicable. References is another area where I've seen problems, and those problems come up if the reference requirement potentially excludes prospective residents based on a protected characteristic. And an example, I've done a training for a co-op that was sued because they had what was called as a shareholder reference rule. And that was a requirement that applicants have to include letters of reference from a current shareholder or member. And why that was problematic is because the complex was overwhelmingly white, and this shareholder reference rule, there's some evidence that it was used as a way to exclude people of other races. And similarly, though maybe less dramatic, would be preferring applicants to receive a letter of reference from a current shareholder or member. Generally, it would be best practice to treat all letters of reference equally, depending on no matter what their source might be. Now, another aspect that comes up is the interview stage, right? After the application stage, after the references, are interviews. And so I think it's worth raising the question again: is why is an interview potentially required by a co-op or a condominium? What is it that's going to be learned during an interview that a co-op or a condominium would not learn based on the financials, based on other information upon which a housing decision can and should be made? But if a co-op or condominium board is going to have an interview, there are some basic guidelines that would be worth noting. And one would be for the questions that the board might ask is that every applicant really should be asked the same questions. Consistency is really a key for people who want to follow the Fair Housing Act. And I think it's good to, generally, when giving a training, to assume that the people you're speaking to want to follow the law. Might not always be the case, but I go into training assuming that people want to follow the law and thinking that hopefully my training can help them follow the law. And the second would not be ask any questions that implicate protected characteristics, such as religion. Now, just quickly do a poll based on something that comes up, which is the flip side of this issue, which is how co-op boards or condominiums can handle questions from prospective applicants that might raise Fair Housing Act issues. I'm going to launch this poll now. So if you were on a co-op board, how would you respond if an applicant asked you, is this a safe neighborhood? You should select the best answer. Okay, we'll just spend a couple more seconds and then close the poll. Okay, and I'll share the results. So now there's no, absolutely best way to, there's no, this isn't necessarily the easiest question, but I completely agree with the vast majority of you that, to me, a best practice would be the choice. You should check the crime data from the local precinct, and 84% of you selected that. 13% of you answered because of the Fair Housing Act. I'm not allowed to answer that question, and I think that would be a valid answer, something that personally I would choose the other option, which is to direct the person who's asking the question to a third-party public source of the information. And that will come up in some other examples, which we'll talk about on the next slide, which is, again, looking at the boards, the co-op boards, or the condominium boards, the homeowner associations' answers to questions by applicants. So we talked about, is this a safe neighborhood? Another one that might come up, is this unit in a good school district? And again, how I would suggest answering this is very similar to refer people to a third-party public source of information. So in New York City, for example, there's websites that rank schools or have data about the different schools. Because, I'm not sure what a person means when they ask what, a good school district. And obviously, because of the history of school segregation, schools the issue of schools definitely do raise potentially issues of race, which would be covered by the Fair Housing Act. Would any children live above me? Does anybody in the building speak Spanish? These are questions, you don't know the motivation. Maybe a person wants to know if people in the building speak Spanish because they want their children to learn Spanish, or they themselves want to keep up on their Spanish and speak it. Or they might not want to live with people who speak Spanish. You have no way of noting the motivation. This is one where actually I would be inclined to potentially take a more drastic approach of saying, due to the Fair Housing Act, I'm not allowed to answer this question. People might take other approaches, but that would be the approach that I would suggest. Common areas. So another issue that comes up with condos and co-ops are exclusionary rules. And I definitely still do see rules that apply only to children. So a sign or a house rule that says no strollers in the public areas, for example. And so that is definitely a concern and something which raises an inference of familial status discrimination. Now, of course, it's fine to have rules that prohibit items, private items, or in public areas, but the examples should be wide-ranging and not just examples that would apply only to children, like strollers and toys or tricycles. Similarly, rules that potentially implicate religious practice, like no Christmas decorations outside the unit. Again, a more neutral way to get at that issue, if that's what the co-op or condo association wants to do, is to again say, something to the effect of no private items outside the unit. So accessibility. It's worth just noting quickly that the ADA might have some applicability to portions of private housing complexes that are open to the general public as public accommodations. So if there's a rental office or an area of the co-op or condominium that's open to the public, then that would be covered by the ADA. But generally, we're looking at the Fair Housing Act, and particularly in this context, reasonable accommodations and reasonable modifications. So it's clear that the Fair Housing Act requires condos, co-ops, et cetera, to make reasonable accommodations when they're necessary to afford a person with a disability equal opportunity to use and enjoy a dwelling. And as I said before, reasonable accommodations refer to changes in rules, policies, practices, procedures, et cetera. And Generally, the burden of paying for the cost, if any, associated with the reasonable accommodation would be borne by the recipient of the request, so the entity that owns, manages, sells, or rents the relevant property. So some examples that often come up are parking spaces. Parking spaces is a big common request for accommodations, as are exceptions to a no pet rule. And there are other examples as well. The most useful resource that I know of on reasonable accommodations and on reasonable modifications, which we'll talk about in a second, are the HUD and DOJ publications, which the joint statement by the HUD and DOJ on reasonable accommodations and the joint statement on reasonable modifications, which are very informative. Reasonable modifications, as distinct from reasonable accommodations, are changes to physical structures or structural elements of a dwelling or a common area. And again, the Fair Housing Act requires the granting of reasonable accommodations if they're necessary to afford a person full enjoyment of the premises. So it might be a ramp, it might be widening doorways, etc. And there are examples on this slide of reasonable modifications that might be necessary. Now, the question of who's responsible for paying for reasonable modification is different than the answer for reasonable accommodations. Under the Fair Housing Act, the Federal Fair Housing Act, the requester is responsible for paying for the reasonable modification, and with regard to some interior modifications, particularly in a rental unit, potentially restoring them to their original state at the end of the tenancy. But it's worth noting that the burden of payment might be different under state or local law. In New York State, for example, the New York State law requires payment for reasonable modifications to common areas to be made by, the association, for example, or the board, or the landlord. Now, the reason it's worth noting for federally assisted housing providers, the Rehabilitation Act also changes the burden of payment for a reasonable modification as set forth at the bottom of the slide. Harassment, I set this as an example in particular to note that, first of all, obviously, quid pro quo harassment, where some kind of benefit is offered in return for sexual favors, as an example, is obviously prohibited by the Fair Housing Act. But also the hostile living environment can raise Fair Housing Act problems. If the board is aware that one resident or a group of residents is harassing another resident based on his or her race or sex, etc., and does not take any steps to remedy that situation, that can raise Fair Housing Act issues. Policies, obviously, it's a best practice for co-ops and condominiums and homeowner associations to have a non-discrimination policy, that they should adopt it, distribute it to the board, staff, and residents, have board and staff sign an acknowledgement that they've read and that they're going to adhere to the policy. I also think it's really helpful for these entities to have reasonable accommodation and modification policies, because as we saw before, disability is the most common basis for complaints, and reasonable accommodation and modification requests can be a bit tricky. And so it's, I think, a good practice to have a policy as to how a request can be made, how a request will be processed, and who will decide whether a request will be granted. I want you to note that the Toledo Fair Housing Center has done quite a bit of research and produced a study on how local condominium owners associations have covenants and conditions and restrictions that impact and potentially violate the Fair Housing Act. And they are starting to educate their local community, the real estate community, attorneys, and others about their study. And ultimately, they're encouraging condominium associations to change their bylaws and other legal documents, as well as their practices, to be more compliant with the spirit and the letter of the Fair Housing Law. And the Toledo Fair Housing Center is generously willing to share this report upon request. So in case you want more information about the Toledo Fair Housing Center's condo project, the NFHA will be providing you with the relevant contact information. So training is, to me, the most important thing in conclusion about training cooperatives, condos, homeowner associations is actually to be non-judgmental. I use the example often I do these trainings as a result of settlement agreements, and settlement agreements often have disclaimers, or almost always have denials of wrongdoing in the settlement agreements. And you know, I take those seriously. I don't go into a training assuming that anyone's broken the law. As I said before, I go into a training assuming that people want to follow the law and that I hopefully can provide them with some tools to help them adhere to the law. And in that way, I feel like these kind of trainings are worthwhile because they can further the purposes of the Fair Housing Act in making sure that housing is available to people, no matter what their race, religion, sex, disability, et cetera, might or might not be. Obviously, the recommendation that training should be provided to the board and to staff, and that the board and staff keep records of the training materials and training acknowledgement forms, et cetera. So that's the conclusion of the training. I'd imagine you still might have questions or thoughts, and I look forward to you sharing those.
Kevin, this is Diane. Thank you very much for the presentation. We do have quite a few very interesting and some quite difficult questions. I will give you, I'll start with a few. How do you properly serve notice of a fair housing complaint to a condo association? Is serving the board sufficient, or do you have to serve all of the individual unit owners?
Okay, so no, I would not serve all of the individual unit owners. I would, again, depending on the facts of the case and what's being alleged, I would serve the board, you know, which might or might not be, you know, I guess depending on whether it's cooperative, et cetera, whether or not the co-op is incorporated. You know, if it's incorporated, you'd want to serve it on the relevant entity, the relevant LLC, or whatever the entity might be, as well as the board. But I would not serve the individual unit owners unless, you know, I guess unless they're implicated in the alleged conduct.
We have a question about disability. Does a person have to provide documentation of a disability? For example, must they qualify for disability in order to meet disability determination? So in order to obtain a reasonable accommodation or a modification, generally I would say, you know, I recommend that when people make a request that they state why they're making the request, why they have a disability, and how it connects to the reasonable accommodation or the modification that they're requesting. For example, if someone is asking for a parking spot that's closer to their unit, I would suggest that they state, for example, if this is, you know, the case, that due to a mobility impairment, I, you know, use a wheelchair, and or let's just say this, due to a mobility impairment, I need a parking space that's within 100 feet of my unit. My current space is not that close, and in order for me to you know, get in and out of my unit, and I need a space that's closer than my current space. So I'm requesting, I know that you allocate spaces generally based on unit number, but I'm asking you to make a reasonable accommodation to that general policy and allocate me a space that's closer to my unit. And now the board might come back and say, well, can you give us proof of your mobility impairment, et cetera. You know, people can provide detailed medical information when they make a request, but there's
no need to include detailed medical information when you make a request. Now, of course, a board might come back and ask for some medical information, and if that request is reasonable, you should provide that documentation. There's an interesting example which might be helpful in drawing a line on what a condominium association can and cannot ask. That's a pretty recent case from Florida. It's called Bogota, I think it would be pronounced first, Altamonte Heights Condominium Association. And the site's 2012, WL for Westlaw, 6562766. And the case is interesting just because the condominium association actually went back and forth, and it is supposed to be an interactive process with the person who requested a reasonable accommodation to keep a pet, but went back and forth with 3 different letters asking for more and more documentation with each letter. And their last letter, they had 10 questions, including the total number of hours and sessions of mental health treatment that the requester received. And the court found that questions such as that were far too invasive and that effectively constituted a denial or at least an unreasonable delay in granting the request.
All right, I have another question. Are all members of an association liable for discrimination or just the board?
So again, it would depend on depend again on the facts of the situation potentially. But that being said, if for example, if someone applies to live in a co-op and again, it's a little bit tricky just because it depends. Like, so for example, if a co-op is incorporated or is an entity, then the entity could be responsible, and to the extent that co-op members, basically are paying into the entity, they could end up liable for some of the, potentially, for example, compensatory damages, et cetera. But so, just to use the example of a co-op, so the entity could be liable, the board could be liable, and I guess the individual members of the co-op, while not necessarily, I guess I wouldn't say strictly liable in terms of for the violation, might be on the hook for some of the costs of the violation.
Okay. Can a religious figurine, like a cross, for example, be put on the door of a tenant living under or within homeowner association rules?
So this is an issue that comes up. There's been some litigation on this that's interesting and not necessarily clear cut. But so let's say, just to flesh that out a little bit, that the condominium association said, it all depends on context. So the condominium association again could have a blanket rule that says, no private objects whatsoever can be put in the public areas, including with example on the door, door frame. If there's no other evidence that there is a discriminatory basis for that decision, that might be a tough case for someone to prove that it's religious discrimination if they're prohibited from putting a religious figurine on the door. That being said, there definitely have been cases where a rule in the context of how it's selectively enforced, for example, or how it was motivated or why it came to being, has raised the inference that the rule infringes on or expresses a preference or limitation based on religion, and then that would potentially be religious discrimination under the Fair Housing Act. So I kind of hate that a lot of my answers are, it depends on the context, but that fleshes it out a little bit, and that can refer you to some cases on this issue, including there's an interesting case in the Seventh Circuit called Block versus Frischholz, and that was actually the case that's very heavily litigated that actually was heard en banc by the Seventh Circuit. The citation is, oh, I apologize, I don't actually have the citation offhand. I have the lower court decision, the first Seventh Circuit decision, which is 533 F. 3rd 562, but then it was heard en banc. But anyway, this case involved hallway rules by a condominium association, and noted that fact issues like the ones that I raised precluded summary judgment on an intentional discrimination claim, and so it had to do with some of the behaviors and the way in which the rule was enforced that were fact specific to that case.
All right, we have a question about support animals. What can be considered in determining whether allowing an emotional support animal is a reasonable request, specifically with animals that have a vicious reputation, for example, pit bulls?
Well, this is a question that does come up. The key thing to remember with reasonable accommodation requests are that you also have to take into account whether or not there are, if a condominium or a co-op board is answering a request by saying that, by denying it and saying that the request would basically be a direct threat to other residents. For example, I'm using the bull pit, the pit bull example. The condominium or the co-op association have to take into account things that might mitigate the potential threat. So, for example, with regard to a pit bull, and we've actually had recently a case on this question, is could a muzzle, does the pit bull itself, this specific one, have any history of biting? First of all, it would be important to consider. But also, let's say even if there was a history of one bite, for example, whether or not a muzzle could be used, so there could be other techniques that could mitigate the potential harm that the condominium or the co-op association is citing in denying the request. So a condominium or co-op association could consider, whether or not an animal, to take a more extreme example, is one that is, domesticated or not domesticated, et cetera. But it is worth noting that they would have to consider whether or not the alleged threat could be mitigated in any way short of denying the reasonable accommodation request.
All right, here's a question regarding cooperatives again. The co-op board asks older prospective buyer the questions, why do you like the unit? Residents in that building are younger than those in the other area. Do you think you would be comfortable there? These questions are during the interview process. The buyer was financially qualified, but the board turned down the buyer. Is there discrimination?
I'm sorry, can you read that again? I apologize.
Sure. A co-op board asks older prospective buyers the question, why do you like the unit? Residents in that building are younger than those in the other area. Do you think you'd be comfortable there? These questions were asked during the interview process. These older buyers were financially qualified. The board turned them down. Is there discrimination?
So this is one where, how I like to handle, so let's say this question was asked to me at a training. So I would say, so let's think through, let's go through the protected characteristics of the Fair Housing Act, the Federal Fair Housing Act. And if we go through the characteristics, we see that age is not covered by the Federal Fair Housing Act. And so discriminating in this case, which I do think it's discrimination based on age, based on the facts presented or potentially, and But depending on where you live, that might not be a problem, right? In New York, state and city, age discrimination is prohibited under the state and local laws, so that would be discrimination. But in other places where age is not covered by the state and local law, it would not be because age is not covered by the Federal Fair Housing Act.
Okay, thank you. What about modification to the front entrance to a building that has been designated as an historic landmark?
Yeah, so so let's say there's a co-op or a condominium and a potential buyer or a current resident. There are two steps to the beginning, to the entrance, and it's an old building. The request is made to add a ramp. So the person explains why they need a ramp and makes the request. And then the co-op and the condominium or the homeowner association would have to consider the request. And among the defenses to such a request, or the reasons why a board might turn down a request, might be, for example, that it's structurally infeasible, that it would be an undue burden based on the cost of the modification, et cetera. And so one of those things that a co-op board, might come back with and say is that, if we can't make that change because of the, it's a historical building and we're not allowed to make modifications to it. And so, that would depend on what the, you'd have to kind of look at the local law, et cetera, what it says, what the exceptions might or might not be to it. But it could be an example where the co-op board or the condominium might not have to comply with the request, or might have to, come back with an alternative. Maybe there's a way to do it that would still comply with the relevant law. And so that's a long way of saying basically that a board would, probably have an engineer or an architect look at the question as to whether or not it could be done, come back to the resident with a response. It's supposed to be an interactive process. Maybe there could be a solution that would be feasible under, under the relevant laws, whether it's for another example that maybe comes up more commonly here is how much room there is on the sidewalk to build a ramp, right, without blocking too much of the sidewalk. And so that is something that there's going to have to be back and forth on. There's going to have to be some proof put forward. But it is true that reasonable modifications can be denied in some circumstances if they're structurally infeasible or if they'd be an undue burden in terms of the cost of the request. So I use the example often of, let's say, an 8-unit building. It was built in the 20th century. Person on the top floor can no longer navigate the staircase, and they ask for the landlord to put in an elevator. Now, it might depend on the circumstances, how much revenue or money the landlord has, but generally speaking, that would be one where I think the request would be an undue burden to install an elevator in a small building like that. But there might be middle grounds that could fit the bill. Potentially, the person could transfer to a unit on the lower floor, or there could be some other type of lift that could be installed.
Is it legal for a homeowners association to require confidential information, such as report cards of families with children?
Well, I'm going to separate that out. Like confidential information, I think that often co-ops request a lot of information that's quite private about financials, et cetera, and that's fine. However, report cards for children, something that's targeting children or families with children for a particular requirement, to me would be clearly a violation, setting different terms, conditions, privileges, et cetera, on a unit based on a protected characteristic, right? Because it's only requiring families with children to provide this information, which to me is pretty clearly familial status discrimination.
All right. Just trying to find a few more questions. What would be your thoughts about the HOA's Fair Housing Act exposure relative to a disabled owner that is a smoker and a complaint from an adjacent homeowner with health issues aggravated by cigarette smoke in a townhouse-type condo setting?
Can you, what was it HOA? What was the, whose exposure?
Well, the question is, what would be your thoughts about the HOAs, the Homeowners Associations, Fair Housing Act exposure relative to a disabled owner that is a smoker and a complaint from an adjacent homeowner with health issues aggravated by cigarette smoke in a setting such as a townhouse-type condo? So I assume that means in the same building you have multiple units.
Right. So, I guess how I'm thinking of that is I'm thinking it's irrelevant that the person who, it's basically irrelevant that the person who smokes has a disability. So I'm focusing on the person who is being bothered by the smoke has a health-related issue, so I'm going to say that's a disability. Let's say they have asthma, and let's say it qualifies as disability under the Fair Housing Act, and that they're making a request. Generally speaking, the homeowner association allows people to smoke in their units. And so this person is making a request saying, I want you to make an exception to that general rule and prohibit this neighbor of mine from smoking in his unit. And I think that's a request that can and has been made. Would the homeowner association have to grant it? I would say that what I would say would be the homeowner association probably would want to engage in the interactive process and see if there's a middle ground that could satisfy the person's request or protect their health without limiting the right of the person to smoke. So, for example, examples that I've seen have been the homeowner association maybe helping the person get I forget the name of this filter, but a special type of filter that cleans the air, that could be maybe placed in the common area, that could be placed in the unit, that could be placed in both units, et cetera. So, so I think the answer that I would give to that would be that the homeowner association would want to explore during the interactive process potential solutions that could address the concerns raised by the person who has severe asthma.
Well, thank you. It is 3:30, and we're at the end of our time for the webinar. Kevin, if you could just advance the slide. Is there one more slide there for you?
Yes.
Okay. Oh, well, I just as a reminder, many of you sent in questions asking for a copy of the presentation. And just a reminder that you will get an email probably by tomorrow with a link. You can download the presentation, and we'll ask you to complete a brief evaluation. We had a series of 3 webinars in this training series that were offered in September and 2 in October. The first one was discriminatory internet advertising. The second one that was offered 2 weeks ago was education and outreach strategies, and then today's webinar as well. All of these webinars, probably starting sometime in November, will be available. They've all been recorded, as well as all the questions and answer sessions. And I'll send you an email. That way, if you missed one of them, or you'd like to hear it again, or you'd like to forward the invitation to other fair housing advocates, you may do so. That way, if you missed anything, there's still the opportunity to go back and listen to our webinars. Well, that concludes the webinar. We're going to sign off now, and thank you again for attending. That's the end of our webinar.